election was held on the basis of the judgment of the Court of Appeal, which was to the fact that, yes, this guy changed his name many times. Not that he forged any of the certificate. There was no such proof. Therefore, he can contest the election. On the basis of that judgment, the people voted, which means by that judgment, the election was valid and legal. As of that date, there was no pending appeal before the Supreme Court, whereby INEC could be accused of having violated the doctrine of least pendens, i.e., since you knew a case was in court, why did you hold the election? As was the case in the case of Obi and INEC, Peter Obi and INEC. So it was after the conclusion of the election that the PDP filed an appeal in the Supreme Court. With profound respect, the attention of the Supreme Court was not drawn to the legality of that appeal. The case had become spent. So what their lordships ought to have done was to say, as the lawyers, can you address us with respect to our jurisdiction? Because Section 133 of the Electoral Act stipulates that upon the conclusion of an election, and once candidates are declared, any challenge of the conduct of the election or the qualification of the candidate shall be heard and determined by an election petition tribunal.
Have continued to trail the Bayelsa governorship election judgment by the Supreme Court. A senior advocate of Nigeria, Mr. Falana, believes that the opportunity for a review of the judgment will further develop and strengthen the country's laws. In an interview with our judiciary correspondent, Shola Shoyele, Mr. Falana says the apex court lacked the jurisdiction to entertain the matter, which he believes should have gone before the election petition tribunal.